Assalamualaikum and hi everyone. This will be a video presentation prepared by Group 2 for our second assignment of Equity and Trust 1. These are the list of group members of Group 2 and we are assigned to the question 1 for our assignment 2. In question 1, Shifa has moved to TRY Village in Kedah 2 weeks ago. TRY Village is a peaceful residential area that is equipped with a football field and also a botanical green park. Shifa's hobby is to collect drones. Last week, she has flown 2 models of drones above the roof of his neighbors and landed in the botanical green park. The residents of TRY Village are not satisfied with their act and voiced their satisfaction to Kamal, who is the president of the Residents Association. Kamal is then approached Shifa and asked her to stop flying the drones in the residential area, but she refused. In another situation, Hazim has resided in TRY Village for almost 10 years. From his house, Hazim can directly see the view of the botanical green park. However, KFA's Nuremberg, which is the developer of the village, has built a building that obstructed Hazim's view of the botanical green park.
Oh no!
So, what are the options available for Kamal and Hazim? This will be answered in the next part of our video. Issue 1. Before we start, let me explain to you a bit on what exactly is injunction. Injunction is one of the equitable remedy by order of the court along with its effect that functions to either prohibit the defendant from repeating or continuing his act. By analyzing Kamal's situation, the very first issue that can be derived from his case is that whether Kamal can apply for perpetual prohibitory injunction from the court in order to stop Shifa from flying her drones in the residential area. So moving on to the law part, there are 2 authorities that are applicable in Kamal's case. So firstly is Pacific Relief Act. Precisely on injunctions part that are stated in section 50, section 51, subsection 2, section 52, subsection 3, subsection B, and also illustration P, and lastly section 54, subsection G. So we will move on to the second authority, which is Malaysia Drone Law. So moving on to the second authority, aside from Specific Relief Act, so this authority is named as Malaysia Drone Laws 2019. This specific law is applicable to Kamal's situation, and it is important to note that this specific law is provided by the UAV Systems International. So after we have analyzed this law, we managed to find out that in this law, it provides that operators of the drones must ensure that they follow the following drone laws every time when they fly their drones in Malaysia. So first, you cannot fly higher than 400 feet or 122 meters. Second, you cannot fly within 50 meters from any person, vehicle, or structure not associated with flying the drones. Third, do not fly over crowds or densely populated areas. And lastly, respect others' privacy when flying your drones. So these 2 laws are very much applicable to Kamal's situation. And now, I'll pass the floor to the next presenter.
Besides the law on trespass, it is also important to point out the law on nuisance. There are 2 types of nuisance, which are public nuisance and private nuisance. The issue here is relevant with private nuisance. Private nuisance means unreasonableness or unlawful use of one's property that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. If such enjoyment to the land is being infringed by non-physical interference, for example, nuisance by way of noise, the plaintiff only need to prove non-physical damage, such as disturbance. The 3 fundamental principles in assessing prohibitory injunction can be found in the case of Aishwarya Engineering Sendirian Berhad against Delta Structure Sendirian Berhad. The principles are: firstly, the judge has to determine whether the totality of the facts presented to him discloses critical issues to be tried. Secondly, the court must determine where the justice of the case lies. Thirdly, the principle stipulates to examine whether the applicant will suffer irreparable harm if the injunction is not granted. In the situation where the court has no means to assess a case in the aspect of adequacy of damages, an injunction will then be granted based on balance of convenience. According to the House of Lords in the case of American Cyanamid Company against Ethicon Limited, the injunction is aimed to protect the plaintiff against injury resulting from the violation of his legal rights, where the case could not be adequately compensated in monetary terms even if he succeeded the case.
Upon deciding with the crewmates, we have decided to include three latest cases, which first, the MBR Acres Limited and others versus Free the MBR Biggers, formerly known as the Stop Animal Cruelty Huntingdon and others, where in this case, despite the injunction was not granted by the court, the court mentioned that the balance in the judgment of the case was struck in the present society, where the principle is that the right of an owner in the airspace above his land is restricted to such height as is necessary for the ordinary use and enjoyment of his land and the structures upon it. Hence, the prohibitory injunction can be granted when the court deemed necessary. Second, we have the case of Washington Development Sdn Bhd versus Success Portfolio, where in this case, the plaintiff instituted a private nuisance action and sought a perpetual injunction against the defendant as the bad smell from the defendant pig farm had affected the plaintiff's sale of residential houses and shop houses. The then judge of the Court of Appeal had allowed the appeal only in respect that the smell emanating from the defendant pig farm was a reasonable factor that established the element of nuisance which allowed the appeal on perpetual injunction to be granted. Last, we have the Lai Kong Lok and another versus Ting Si Leng, where the defendant was sued by his neighbor for always parking his car in front or near to the front of the plaintiff house. The defendant's action caused inconvenience to the plaintiff to enter and to reverse his car out of his own houses. Also, when the defendant parked his car at a nearby corner, had obstructed the plaintiff's field of vision of oncoming vehicle from the road, which can cause accidents. The plaintiff thus filed a lawsuit and applied for an injunction from the court to stop the defendant from continuing with the behavior on the ground of private nuisance. In this case, the High Court held that a private nuisance had been established because the manner of parking of the defendant is illegal and it is unreasonable and had caused obstruction, where it directly creates a dangerous situation, and the court granted an injunction sought by the plaintiff to restrain the defendant from continuing with the nuisance. Since there were private nuisance and trespass found in the present case of Kamal, he can claim for preventive injunction under Section 50 of the Specific Relief Act 1950, where a perpetual injunction is granted upon the merits of Kamal's case. Hence, solid evidence on Shifa's act threatens the Tiarwa resident enjoyment need to be submitted, where the invasion has caused mental distress for the neighbor with the unnecessary noise interference, has made Section 54 subsection G is overruled. Furthermore, Shifa's action violated the Malaysia Drone Laws 2019, where the drone was flown nearby people and structures. She then flew her drone over the botanical park, where could have a crowd residents presence while doing recreational activity. These all constitute to trespass and thereby breaching her neighbor's privacy.
The three fundamental principles of prohibitory injunction derived from the case of Eshwara Engineering are seen in the present case. Firstly, Shifa flying the drones causing nuisance and trespass are the facts that represent the critical issues to be tried in this case. Secondly, the justice of this case lies in restoring the residents of Tri Village's reasonable comfort of life. And thirdly, it can be seen that the residents of Tri Village would suffer irreparable harm if the preventive injunction was not granted, where the rights of comfort and life would be compromised. Next, according to the principles of balance of convenience derived from the case of American Sainamid, the balance lies in favor of Kamal, as his and the residents of Tri Village's rights of life and comfort would be compromised and damages would not suffice as a remedy. In the latest decided cases, the English case of MBR Acres Ltd is referred to as there is no current case relating to drones in Malaysia. This case is intended to be read with the provisions of Malaysian Drone Law 2019. The flying height of a drone directly above the rooftop is sufficient to constitute interference in airspace, leading to trespass. Next, in applying the case of Washen Development Sdn Bhd, private nuisance exists in the present case as the act of flying a drone causes noises and disturbances to the comfort of several residents of Tri Village, including Kamal. And Kamal can bring a suit of private nuisance as he has similar interests in his land as his neighbors have of their own land, which are affected by Shifa's actions. Lastly, flying drones for recreational purposes in the residential area is seen as unreasonable and dangerous, as it could be mishandled and cause injury to the residents or property of the residents, as similar to the obstructions in referring to the case of Lai Kong Lok and another. In conclusion, Kamal may bring a suit against Shifa on the grounds of private nuisance and seek for prohibitory injunction by way of perpetual injunction to stop Shifa from continuing flying her drones in the residential area.
Issue 2.
Issue arose when FKS Injunction Berhad has built a building obstructed Hazim's view of the Botanical Green Park. Previously, Hazim can directly see the view from his house.
Injunction is an order to protect a person's legal right and interests. It may prevent the commissions or continuations of a wrongdoing of another. The issue here is whether Hazim can apply for perpetual mandatory injunctions from the court to compel the KFA Sdn Bhd to demolish the building. In Malaysia, the mandatory injunctions is explicitly allowed under Section 53 of Specific Relief Act 1950. The court has a discretionary power to compel the performance of an act by granting an injunction to avoid the breach of an obligations. In simpler words, the court defined in the case of Aswala Engineering Sdn Bhd, mandatory injunction is an order that's capable to direct a person to do something, like repairing a committed omissions or like restoring something back to its prior positions, which is by undoing a wrongful act. In the sense of discretions, let's look at the case of Kia Hamza. It is discretionary in nature and will be granted with care and cautious on a case-by-case basis. Indeed, the mandatory injunction will be less readily granted when compared to the prohibitory injunctions. This is because we have to know that the alleged wrongdoing has already begun, and by undoing it will certainly cause some substantial damage to the defendant. The mandatory injunctions have the effect to pull down an existing building as per illustrations A in the Section 53. For example, in the case of Allen vs. Greenwood, the plaintiff claimed that there's a newly built building which obstructed the light to his greenhouse, which he planted for over 20 years. Hence, he sought a mandatory injunctions to demolish the building on the ground of nuisance. The court found that that building did affect the beneficial use of the plaintiff greenhouse for its ordinary purpose. For greenhouse, it shall entitled to have a right to an extraordinary amount of light and further benefit like having the sun rays on the plant. Hence, the court granted the injunctions following the sincere needs of the plaintiff.
Good day to Madam and my friend. I'm Lim Juni. We have understood that the function of the mandatory injunction, but we have to be aware that there are certain exceptions that disallow the grant of mandatory injunction. One of them is when the alleged act
is not clear to be a nuisance, and this situation is enunciated under Section 54, paragraph G of the Specific Relief Act. So, the question is whether obstruction of view is a nuisance. To answer this question, first we refer to the UK case of Dennis against Davis. The test applied in this court is where it's a reasonable man test, that is, whether a reasonable person during the ordinary use of the house would feel annoyed. In this case, obstruction of view is a nuisance because the River Thames view is the central selling point of the residential area. Reasonable person will feel the same. But generally, the judgment held in Hunter against Canary Wharf Limited will be followed. That is, erection of new building shall not constitute a nuisance. Let us scrutinize the principle from the latest decided cases. In the case of Injunction, the plaintiff failed to establish that the defendant's conduct was alarming and imminent for the court to grant mandatory injunction as a protection to them. The court held that since the defendant's conduct is not clear to constitute a nuisance, therefore mandatory injunction cannot be granted. Moving forward to the UK case of Network Rail Infrastructure, the claimant wanted to compel the respondent to remove the north bridge through a mandatory injunction. However, they failed to do so because the court viewed that the operation of the injunction was vague because diminution of the property remained even if the north bridge is removed.
In application, it shall first be aware housing situations falls within the instance of refusing mandatory injunction. Generally, the destruction of a scenic view is not tantamount to a nuisance. And distinct from Dennis' case, Tri Village was not designed purposely to enjoy the view of the botanical garden. Therefore, injunction can be refused under Sections 54G of Specific Relief Act, since the situation is not reasonably clear to result in nuisance. Secondly, it is observed that the obstruction caused by the building is not imminent. By referring to the judgment of Injunction, Hazim's situations did not reach the threshold that satisfied the court to grant a mandatory injunction. Even if the obstructions might have caused a certain level of unpleasantness to Hazim's, it is insufficient to cause a serious injury that is reasonably clear to cause nuisance. Thirdly, mandatory injunctions cannot be granted in a situation where the applications of mandatory injunction appear to be vague, by referring to the principle in the case of Network Rail. Besides that, the court tends to be more reluctant to grant mandatory injunctions in Hazim's case, as the alleged wrongdoing had already begun when the building had been completely erected, which is different from the merits in Dennis' case. In conclusion, Hazim cannot apply for a perpetual mandatory injunction from the court to compel FKS and Jan Berhad to demolish the building.